Good day, everyone. My name is Ekina Tracy Guzura. I'm a GZ2 law student and I'm studying jurisprudence. My lecturer is Mr. Maposa. So I'll be taking you through sociological jurisprudence. Okay, so sociological jurisprudence is a branch of jurisprudence that seeks to examine the relationship between law and society. It is concerned with the social, political, economic factors that shape the development and operation of the legal system. Sociological jurisprudence emerged in the early 20th century as a response to the limitation of traditional legal theory, which focuses primarily on the formal aspects of law and ignores the social context in which it operates. This video provides a comprehensive overview of sociological jurisprudence, including its history, key concepts, and contribution of legal theory. History of sociological jurisprudence. Sociological jurisprudence emerged in the 20th century as a response to the limitation of traditional legal theory, which was primarily focused on the formal aspects of law and ignored the social context in which it operates. The earliest proponents of sociological jurisprudence were legal scholars such as Roscoe and Eugene, who argued that the law should be understood as a social phenomenon rather than an abstract set of rules and principles. Roscoe Pound, in particular, is often credited as one of the founders of sociological jurisprudence. Pound argued that law was not simply a set of rules, but rather a social institution that was shaped by a variety of factors, including social norms, economic conditions, and political power. He believed that the law should be responsive to the changing needs of society, and that legal institutions should be designed to promote social welfare. Eugene, another early proponent of sociological jurisprudence, argued that law was not simply a product of the state, but rather a reflection of the social norms and values of a particular community. He believed that legal systems should be studied in their social context and that legal rules and principles should be examined in light of their social and cultural significance. Moving on to key concept of sociological jurisprudence. Okay, so sociological jurisprudence is based on several key concepts which are central to the understanding of the relationship between law and society. The concept including social context. Sociological jurisprudence emphasizes the importance of understanding the social, economic, and political concepts in which the law operates. Legal rules and principles cannot be understood in isolation from their social context, and legal institutions must be designed to address the needs and contents of the community they serve. Social norms. Sociological jurisprudence considers that legal rules and principles are not created in a vacuum, but rather are shaped by the social norms and values of a particular community. Legal system must be responsive to the changing society norms, values of society, and legal institution must be designed to promote social welfare. Then there's social justice. Sociological jurisprudence emphasizes the importance of social justice in the legal system. Legal rules and principles must be designed to promote equality, fairness, and legal institutions must be designed to protect the rights of all members of the society. The fourth one, legal pluralism. Sociological jurisprudence considers that legal systems are not monolithic, but rather are composed of a variety of legal, traditional, and practices. Legal pluralism emphasizes the importance of recognizing and respecting the diversity of legal systems and practices in different norms. Moving on to contribution of sociological jurisprudence to legal theory. Sociological jurisprudence has made several important contributions to legal theory, which have helped to shape our understanding of the relationship between law and society. These contributes include the recognition of law as a social phenomenon. Social jurisprudence has helped to shift the focus of legal theory from an abstract analysis of legal principles to a more nuanced understanding of social, economic, political context in which law operates. This recognition has helped promote a more realistic and pragmatic approach to legal theory. The emphasis on social justice, sociological jurisprudence help to promote just approach to legal theory by emphasizing the importance of social justice in legal systems. Sociological jurisprudence has helped to promote a more inclusive and equitable legal system. Thirdly, the recognition of legal pluralism. Sociological jurisprudence has helped to promote a more inclusive and diverse approach of legal theory by recognizing the importance of legal pluralism, by acknowledging the diversity of legal systems and practices in which communities. Sociological jurisprudence have to promote more respectful and tolerant approach to legal theory. For example, in the case of Chikwada versus Chikwada, and also in the case of Kwatizo versus Matone. Okay, so the promotion of interdisciplinary research. Sociological jurisprudence has helped to promote interdisciplinary research by encouraging scholars to draw on insights from a variety of disciplines, including sociology, anthropology, economics, and political science. The interdisciplinary approach has helped to promote a more holistic understanding of the relationship between law and the society. Relevant examples and illustration. Here are some examples and cases studies that illustrate the principle of sociological jurisprudence. Brown versus Board of Education. This landmark USA Supreme Court case struck down racial segregation in public schools, recognition that separation education facilities are inherently unequal. Sociological jurisprudence helped to inform the decision by highlighting the ways in which segregation reinforced social inequality and perpetuated racial discrimination. The Saints and the Roughnecks. This classic study examines the ways in which social context shapes legal outcomes. Another example is the Chambliss observed that two groups of high school students who engaged in similar forms of delinquent behavior were treated very differently by the legal system, with the upper class saints receiving lenient treatment and the working class roughnecks facing harsher consequences. This study illustrates that the importance of understanding the social economic context in which a legal institution operates. Legal conscience. This study explored how ordinary people understand they interact with the legal system. Silbey found the legal consequences is shaped by social context with people from different social backgrounds viewing the law and legal institution in different ways. The research highlights the importance of understanding the social and cultural dimensions of the law. The Watergate scandal. The Watergate scandal in the United States demonstrates the importance of accountability and transparency in the legal institution. The scandal involved a complex web of illegal activities by government officials, including wiretapping, burglary, and obstruction of justice, which were uncovered by journalists and investigators. Sociological jurisprudence emphasizes the importance of designing legal institutions that promote transparency and accountability and that are responsive to the needs and concerns of the community they serve. Also, the Indian Constitution. The Indian Constitution is an example of a legal document that reflects the social and cultural context in which it was created. The Constitution enriched principles of social justice, equality, and secularism, and recognizing the diverse cultural and linguistic identities of the Indian people. The Constitution reflects the social and political aspirations of Indians, diverse communities, and exemplifies the principles of sociological jurisprudence by recognizing the importance of social context in shaping legal institutions. Okay, moving on to relevant areas of law influenced by this jurisprudence and analysis of the Zimbabwean legal system. Okay, the background. Zimbabwe is a developing country that continues to grapple with social, political, economic challenges. The legal system plays an important role in addressing these issues and shaping societies. This video discusses the concept of sociological jurisprudence and examines its application within the Zimbabwe legal system. Sociological jurisprudence emphasizes law as an instrument of social change and seeks to craft legal rules that align with human welfare and social progress. Key elements of sociological jurisprudence in Zimbabwe include containing the sociological context in legal interpretation, balancing rights and duties to promote sociological stability, and using law to remedy social problems and injustice. While Zimbabwe's formal legal system has traditionally followed a more conservative and doctrinal approach, elements of sociological jurisprudence can be seen in certain areas of law such as labor law, land reform, and domestic violence legislation. Sociological jurisprudence offers a perspective that may help Zimbabwe's legal system adapt to a new socio-economic condition and improve its effectiveness in bringing about social justice. Zimbabwe's legal system is based on Roman Dutch law and English common law that were inherited from the colonial period. The courts have traditionally followed a strict doctrinal approach focused on precedents and establishment principles. Since independence in 1980, elements of sociological jurisprudence have emerged within the legal system, particularly in areas related to economic and social rights. Okay. Customary law in Zimbabwe. Sociological jurisprudence has been influenced in shaping Zimbabwe's approach to customary law. Customary law is a body of unwritten laws, customs, norms that govern interperson relationship in traditional African society. After independence in 1990, Zimbabwe had to decide how to integrate customary law into a formal legal system. Sociological jurists argued that for customary law to effectively promote social welfare, it must evolve with change in socio realities rather than strict codified. They pointed out that some aspects of customary law, such as practices discriminating against women, were no longer consistent in Zimbabwe's social values and human rights. So, this led to Zimbabwe's courts to adopt a repugnance clause that allows judges to declare any aspect of customary law that violates public policy, natural justice, or the constitutional to be unforeseeable. Judges have invoked an approach to invalidate certain discriminatory provisions within customary law. Furthermore, since 2000, after the famous Magai versus Magai case, legislation has been passed to reform customary law in line with principles of gender equality, such as Domestic Violence Act of 2006 and the 2013 Constitution, which includes Section 56, which provides for the twin right of equality and non-discrimination. This development demonstrates how sociological jurisprudence has shaped Zimbabwe's approach to balancing customary legal traditions with broader social goals of justice and reform. The focus has been on adapting rather than strictly codifying customary law to align it with Zimbabwe evolving society. Moving on to human rights and civil liberties. Social jurisprudence in Zimbabwe have also drawn on social context when interpreting and applying human rights provisions. For example, in the case involving the right to education, judges have considered factors such as poverty, lack of infrastructure, and resource constraints in determining the scope of the state's obligation to provide free and compulsory primary education. In criminal justice, sociological jurisprudence has informed judges' interpretation of constitutional provision against cruel and inhumane punishment. Judges have cited prisons, overcrowding, inadequate conditions, and lack of rehabilitation facilities as social realists, necessitating a more liberal interpretation of these rights. This has led to judicial interventions aimed at reforming prisons' conditions and reducing overcrowding. Sociological perspective has also been influenced in case addressing groups and minority rights. Judges have cited the lived experiences and socio-economic marginalization of groups such as women, the disabled, and the LGBT community in recognizing and enforcing their constitutional rights. This demonstrates a shift away from purely legalistic approach towards a more contextual understanding that considers the realities and needs of groups. Okay. Law enforcement and criminal justice, the current amnesty release. Lawyers in Zimbabwe have advocated for more sociological grounded approach to law enforcement and criminal justice. They argue that overemphasis on strict enforcement and harsh punishment often fails to consider the social realist and drive criminal behavior. This has led to calls for criminal justice reforms focused on restorative rather than purely retributive justice. There are also proposals in increasing the use of diversional and alternative sentencing approach that address the root causes of crime and reintegrate offenders into society. Such reforms are in line with sociological jurisprudence, emphasize on promoting social welfare and reform through the law. While only some of these reforms have been implemented, sociological jurisprudence undoubtedly influence the debates on criminal justice policy in Zimbabwe. There is a growing recognition that restricted enforcement alone cannot reduce crime. A holistic sociological ground approach is also needed. Considering the social context, Zimbabwe courts have begun to consider the social context and circumstance when interpreting and applying laws. For example, in labor law cases, courts have recognized the unequal bargaining power between employers and employees and interpreted labor law in a manner that favors workers' rights. Judges acknowledge that workers require greater legal protection in the context of globalization and economic changes. And in land reform cases, courts have interpreted laws in the context of Zimbabwe's historical injustice related to land ownership and distribution. The court endorsed aspects of fast-track land reform program initiated in 2000 and allowed the state to acquire private-owned land for redistribution. This showed the court's recognizing the need for law to adapt to the country's socio-economic condition and development goals. Balancing rights and duties. Zimbabwean courts have sought to balance competing legal rights and social interests to promote stability. For example, in domestic violence cases, courts have balanced men's rights to security and protecting against men's rights to privacy and property. The 2006 Domestic Violence Act, endorsed by courts, aims for an equitable balance between protecting victims of abuse and safeguarding accused persons' rights. Using law as an instrument of social change. Zimbabwe's legal system has used law as an instrument of remedy social problems, advance the social justice. The Domestic Violence Act of 2006, for example, aimed to address high levels of spousal abuse and violence against women. Courts have interpreted and applied the law liberally to protect victims and promote gender equality. Sociological jurisprudence can be seen in areas of Zimbabwean law that seek to advance the rights and well-being of marginalized groups. These include labor law reforms that strive for more workers' protections, land reform laws that aim for more equitable land contribution, and domestic violence legislation that works towards greater gender justice. While Zimbabwe's formal legal system remains fairly conservative, judges in specific areas have shown a willingness to craft legal interpretation that advance social progress. Okay, so critics of the theory or approach. One criticism of sociological jurisprudence is that it neglects the formal aspects of law, legal formalism. The approach that sociological jurisprudence sought to challenge emphasized the importance of legal rules and principles as abstract and universal norms that govern human behavior. Sociological jurisprudence, on the other hand, emphasizes the importance of social context in shaping legal outcomes. However, some scholars argue that sociological jurisprudence goes too far in its emphasis on social context, neglecting the formal aspects of law that provide important guidance for legal decision making. One scholar who has criticized the neglect of formalism in sociological jurisprudence is Brian Tamaha. Tamaha argues the sociological jurisprudence plays too heavily on a contextualized approach that emphasizes the social and historical factors that shape legal outcomes. According to Tamaha, this approach neglects the importance of legal rules and principles and necessary conditions for legal decision making. Tamaha suggests that sociological jurisprudence should adopt a more balanced approach that recognizes both the formal and social dimension of law. Another criticism of sociological jurisprudence is that it assumes a straightforward and deterministic relationship between social context and legal outcomes. According to this critique, sociological jurisprudence assumes that social context determines legal outcomes in predictable and linear way, neglecting the complexities and contingents of legal decision making. This critique suggests that sociological jurisprudence oversimplifies the relationship between law and society and fails to account for the multiple purposes that shape legal outcomes. A related criticism of social jurisprudence is that it tends to essentialize social context, assuming that social grounds and institutions have fixed and stable identities. This critique suggests that sociological jurisprudence overlooks the dynamic and fluid nature of social identities and institutions and fails to account for the ways in which social identities and institutions are constantly being redefined and renegotiated. One scholar who has criticized the essential of sociological jurisprudence is Santos. Santos argues that sociological jurisprudence assumes that social identities and institutions have fixed and stable identities, neglecting the ways in which these identities and institutions are constantly being redefined and renegotiated. Santos suggests that sociological jurisprudence should adopt a more dynamic and fluid approach that recognizes the contingents and fluidity of social identities and institutions. So, in conclusion, while still at a nascent stage, elements of sociological jurisprudence can be seen within certain aspects of Zimbabwean legal system, particularly those related to economic and social rights. A more robust adoption of sociological jurisprudence may help Zimbabwean judiciary adapt legal rules to new social realities and craft a legal system that promotes social justice and human welfare. However, for sociological jurisprudence to take deeper root, a transformative change is needed within Zimbabwe's formal legal structures, education institutions, and judicial culture. Zimbabwe's outgoing social, political, and economic challenges present opportunity for a legal system to evolve and embrace a more sociological approach that sees law as an instrument of positive social change. Thank you.